All right. Good evening, everyone. Welcome to the July Summer Maryland State Commission on Criminal Sentencing Policy meeting. We are happy that you are all able to join us. We have declared a quorum. Has everyone had an opportunity to review the minutes from February 24th, 2025?
Yes, ma'am.
Thank you. Can I have a motion to approve the minutes?
Judge Middleton, if I may, just we were contacted earlier today by Mr. Frailing. We did have a misspelling, and we will correct that. So I just wanted to make that amendment known that we will correct the spelling of a name of Mr. Frailing's name, and so it would just be to adopt the minutes with the correction to the spelling.
Okay, thank you. Then do we have a motion to approve the minutes with the correction?
I'll make the motion to approve the minutes with the correction.
Thank you. Second. Thank you. It's been moved and properly seconded that we approve the minutes, the February minutes with the correction. All those in favor? All those opposed? Thank you. The motion carries. All right, so now we have some exciting announcements to make about new appointments and reappointments to the commission. So first, I am pleased to share the news that Governor Moore reappointed Dr. Brian Johnson and Alethea Miller. So yay, happy about that. Thank you. Dr. Johnson was reappointed as the criminal justice policy expert, and Alethea Miller was reappointed as the Victims Advocacy Group representative. Each of these appointments was for a term of 4 years starting on July the 1st, 2025. So thank you and congratulations to them. Next, I'm very pleased to announce that Governor Moore appointed Nikita Ross to a 4-year term as a member of the commission. Ms. Ross is an agent or senior investigator from Kent County with the Division of Parole and Probation in the Maryland Department of Public Safety and Correctional Services. Agent Ross was appointed as one of the 2 public representatives on the commission. So congratulations. Thank you for joining us.
Thank you.
I want to express my appreciation for you accepting the appointment, and to Dr. Johnson and Ms. Miller for accepting their reappointments. We look forward to working with all of you.
Judge Middleton, if I may just interject there, I just also wanted to acknowledge that Agent Ross is replacing Kyle Schur, who served 4 years with us on commission, and his term expired on June 30th. So I just he's not on our meeting today, but I did want to just publicly acknowledge his service and commitment to the Sentencing Commission and express our appreciation for his time with us.
Thank you. We will now have the Guidelines Subcommittee report by Judges Shaw and DeLeonardo.
I think we can defer to staff for, it's really on the reclassification. And
okay.
All right, I'm going to get us started off with the main item on our agenda today, which is the proposed classification of new and amended offenses. Just to let everyone know, the Guidelines Subcommittee met via video conference on June 25th to review these new and amended offenses and to offer the proposed classifications that are presented to you. Since we have a new commissioner and, this is an annual activity, I'd like to just take a minute to just explain the commission's process for how we do this annual activity. So each year, the Sentencing Commission reviews new and revised criminal penalties and considers how the new and or revised criminal penalties will fit within the Maryland sentencing guidelines. And the task of classifying the new and revised offenses is designated to the Guidelines Subcommittee. The staff will first go through all legislation and prepare recommendations that we present to the subcommittee, and then the subcommittee goes through those, and then ultimately that leads to the recommendations that you see before you today. There is a memorandum on this, which you've seen. It focuses on the penalties that have 1 year or greater, because by rule, the Sentencing Commission does not require classification of offenses that carry a maximum penalty of incarceration of 1 year or less. Those offenses are automatically assigned a seriousness category of 7 unless the commission wants to consider something different there. But by rule, we will automatically assign them a 7 unless there's some rationale to do something different. So referring to that memorandum, which is labeled Proposed Classification of New and Amended Offenses for the 2025 legislative session. As you've probably reviewed it, it is a 29-page document. We do not have to go through each page line by line, so we'll be focusing on the first 15 or so pages, but some of that is also the comparable offenses. But we'll ask for a vote for each of the individual bills, the way we have it laid out. And it starts with new offenses that have action recommended. Then we get into changes to existing offenses with action recommended. And then we'll move in, then I'll refer to the rest of the document, which is new offenses with no action recommended, and changes to existing offenses with no action recommended. For your reference, we also provided a supporting document that's labeled Combined File of Legislative Text for New and Amended Offenses from 2025. And that's a PDF document that combines all the legislation together. The bills appear in the order they are listed in that document. Excuse me, the order they are listed in the corresponding memorandum. The way the subcommittee offers seriousness category recommendations is by examining currently classified offenses that are comparable. And so we refer to those as comparables. And what we are looking for specifically in terms of those comparisons is, number one, the type of offense, whether it's a person, drug, or property offense. Number two, the statutory maximum penalty. Third, the misdemeanor felony classification. And then finally, when possible, the nature of the offense. So if we are ready, I'll just go ahead and jump right in for the new and amended offenses. I'll start on page 1 of the memorandum. That is referring to chapters 191 and 192, which relates to Senate Bill 11 and House Bill 179. This legislation prohibits one or more persons from committing a series of thefts from retail merchants with an aggregate value exceeding $1,500. If the crimes are committed in more than one county, they can be aggregated to meet the $1,500 threshold test. The legislation targets organized groups coordinating thefts on a large scale, grabbing merchandise with high resale value. A violation involving at least $1,500 but less than $25,000 is a felony subject to a maximum penalty of 5 years imprisonment and a $10,000 fine. A violation involving at least $25,000 but less than $100,000 is a felony and is subject to a 10-year maximum penalty and a $15,000 fine. And then finally, a violation involving $100,000 or greater is also a felony and subject to a maximum penalty of 20 years imprisonment and a $25,000 fine. The comparables are provided on page 2 of the memorandum. Based on these comparables, the guidelines subcommittee recommends classifying all 3 violations as property offenses with a seriousness category of 6 for the 5-year felony, a seriousness category of 5 for the 10-year felony, and a seriousness category of 3 for the 20-year felony. So I'll present that as the recommendation of the guidelines subcommittee and open it up for discussion. And again, we will ask for a vote. Again, I think we can take each of these bills in a block. It's not for each individual offense. So the block of seriousness categories.
So I think when we discussed this particular piece of legislation, we came to the conclusion that it really is in response to these mall thefts where gangs of people go run into a retail store and just grab everything that they can, be it jewelry or clothing or whatever. Yeah, that's it.
Okay.
That's context.
All right. So you prefer to do these as a block then? So for each recommendation, we can do that.
Yes, I think so. So we could focus on the
Okay.
recommendations on page 1 of the memorandum.
Okay, thank you. Based on the conversation, is there a motion to approve the recommendation of the subcommittee?
Well, it's coming from the committee, so I don't think we need a motion. It's the committee's recommend motion for the body to vote on, so. We don't need a second, I'm sorry.
Okay, okay. All right, thank you.
Phrased it wrong.
Okay, it's been moved. All those in favor? All those opposed? Thank you. The motion carries.
Okay, moving on to page 3, we'll continue with chapters 160 and 161 relating to Senate Bill 81, House Bill 445. Chapter 160, 161 creates a new felony if someone takes actions intended to interrupt or impair the functioning of a 911 call center. This includes cyber attacks on 911 call centers that render them inoperative for a certain period. A violator of this offense is guilty of a felony and subject to a maximum penalty of imprisonment for 5 years or fine of $25,000. Based on the comparables which are provided on page 4 of the memorandum, the subcommittee recommends classing this violation as a property offense with a seriousness category of 5.
Thank you. Did you
The
have
committee
any?
moves for approval.
Thank you. Is there a second? Thank you.
We
All
got a
right.
second.
Is there any further discussion? Okay. All right, it's moved and properly seconded to adopt the recommendation of the committee and classification. All those in favor? All those opposed? Motion carries.
Okay, great. I will now move on to page 5, which is for chapter 545, House Bill 674. House Bill 674 prohibits knowingly and willfully dismembering, destroying, removing, burying, disposing of, or obliterating any portion of human remains with the intent to conceal a crime or aiding or abetting another in violation of this act. A violator is guilty of a felony and is subject to imprisonment for up to 5 years. Based on the comparables, which are listed at the bottom of page 5 here, the subcommittee recommends classifying this as a property offense with a seriousness category of 6.
The committee moves this be accepted by the commission.
Thank you. Is there a second? Thank you, Mr. Finchie. All those in favor? Any opposed? Thank you. Motion carries.
Okay, so we will move on to.
I'm sorry, Delegate Bartlett has a question.
Sure.
I apologize. I did not ask if there was any discussion.
I just had a question. And you're gonna know that I didn't finish the memo when I asked this question. And if it's in the memo, I apologize. How are any related offenses to a person how do they interact with the 911 and the remains, dismembering of the remains? I was trying to get to it really quickly because we were just talking about, we were talking about let me start with House Bill 674 then, to make it easier. So we said committing or aiding or abetting another to commit destructive active to human remains. Why is this a property offense? Is it because the person is deceased and therefore we list it as a property offense?
Yes, I would say yes, because when we talk about cemeteries, we're talking about persons who are not considered alive at the time that the offense occurs. Yeah.
Okay. All right. And so I understand that. And then the other one was on the with the 911 calls. are there later, and this is why I said you'll realize I hadn't read the entire thing, entire memo. Are there later discussions on categorization of any related death or injury from the misuse of 911 or any of the safety mechanisms that are listed in the bill?
Could you give me a potential fact scenario? Maybe I can, I'm not
Well,
sure I understand.
sure. And you know what? I need to pull up the bill to be sure. I can't remember, but I thought we had put in a related crime against a person if someone dies as a result of or is injured as a result of a faulty, swatting basically. And I thought we did, but I can't remember for sure. I mean, we talk about so much during session and I can't remember. Perhaps you all do or had that discussion, or if it's in there later in the memo.
It's not in the memo later. I'm trying to quickly scan that bill to see if that's.
Okay, I'll look at the bill as well.
If we missed it.
I'm sure you didn't miss it. You all are very thorough. I thought there was a discussion on it.
I don't
I think it's
see
in
it.
the minutes. I remember seeing it in the minutes on, it's in the minutes from June 25th, 2025, and it's on page 3 of,
Okay, you're talking about the guidelines, subcommittee minutes.
yeah, that's why I saw the discussion, that a discussion was had. If we're
I think
talking
we
about
did
this, I
have a
don't think she's talking
discussion
about the
about how
same
it-
bill, but that's the same, that's the 911 call conversation that
No, I don't remember us having a conversation about someone being harmed as a result of this.
Okay,
I'd be
Well-
interested to know whether it's in the bill because we certainly can address it.
Right.
I tell you what if Dr. Soleil, if you haven't found it, I'll review it, and I don't want to take up any more time. I'll review it, and if I see it, I can flag you all later.
Yeah,
that's
and we
okay.
can add it to the agenda of our next meeting.
Absolutely.
Okay.
There is.
If I
There's
may,
stricken language that refers to it. I'm now seeing it.
yeah, I thought, okay, go ahead, Mr. Frayling.
Yep, sir.
if I may, and I don't want to speak out of turn, but I thought that it specifically addressed the volitional act on a person or by a person or entities, to basically create a situation that prompted 911 to not be effectively responsive. I don't know if that addresses the senator or the delegate's concern, but that's kind of what I read. And if I'm wrong, please correct me otherwise.
I just think we just need to get clarity. So let's do a little bit more research into what it actually is. It makes sense what both of you have said, but I think we need to look at the language.
Okay.
Because in both situations, you can have a situation where 911 is not actually being effective, and then you can have a situation where they're being effective and a person can still be killed or seriously injured. So I think we need to rely on the language itself. So we will request, Madam Chair, that we defer that specific issue to our next meeting, and the subcommittee will meet in the interim and come up with a recommendation. Is that fair?
That's fair. Okay, so we are going to,
We can still vote on this. Well, we already have. We can
Yeah,
still
we
move
already
forward
have.
with that. It would just be an additional piece.
okay. And, are we asking, I just want to be clear, are we asking Delegate Bartlett, or has she volunteered to provide any additional information for purposes so that
We're
this-
asking Dr. Souley to research the legislation to see if the language that she's referencing is actually there. And if so, then we need to have a discussion about the offense and whether it's a person crime, a property crime, and then what would be the grading of that.
Okay.
Right.
All
Okay,
right.
thank you. And of course, Dr. Soule, if you need me, I'm available.
Okay, great. I appreciate that.
Okay. Well, since the committee did approve
Right. I
the
think we're
last
good.
vote,
Yeah.
we can move to the next block.
Okay. I believe we're now on to page 6. This would be chapters 189 and 190, referring to House Bill 943, Senate Bill 334. This legislation prohibits a person from committing a certain crime of malicious or fraudulent burning that results in the death of or a serious physical injury to a firefighter. A violator of this is guilty of a felony and subject to imprisonment not exceeding 10 years, and the sentence shall be separate from and consecutive to any sentence for a crime based on the act establishing the violation. The guidelines subcommittee identified the comparables that are shown at the bottom of page 6. I will note that this offense includes death or serious physical injury to a firefighter, so the subcommittee agreed with the staff recommendation that we were driven by the 4th comparable in the list of comparable offenses, which is the fleeing or eluding police that results in the death of another person. That's also a 10-year maximum penalty. We thought that was a relevant comparable. Therefore, the subcommittee recommends classifying this as a person offense with a seriousness category of 4. So I present that as the subcommittee's recommendation.
That's our recommendation.
Thank you. I'll take that as the motion. Is there a second? Thank you. It's been moved and properly seconded to adopt the recommendation of the subcommittee. All those in favor? I'm sorry, Mr. Frank, was any discussion? Okay, all those in favor? All those opposed? Thank you. Motion carries.
Okay, moving on to page 7, continuing with chapter 275, which is Senate Bill 123. So the first 2 offenses listed on the table on page 7 are the natural resources, 6-724 offenses. They were provided primarily for informational purposes and because they're all related here. But the guideline subcommittee is recommending no action. The offenses, as you can see, carry a 2-month and 1-year maximum incarceration penalty, respectively. And therefore, as I mentioned earlier, they will automatically be assigned as a seriousness category 7 because it's a penalty of 1 year or less. So I'm going to move on to the third offense. The third offense in the table involves a failure to immediately stop a vessel involved in a collision, accident, or other casualty that results in the death of another person. A violator is guilty of a misdemeanor and is subject to imprisonment not exceeding 5 years and/or a fine of $5,000 if the collision, etc., results in the death of another person. A person who violates the same subsection and who knew or reasonably should have known that the collision, etc., might result in serious bodily injury to another person and serious bodily injury actually incurred is guilty of a felony and subject to imprisonment of up to 5 years and a fine of up to $5,000. Finally, the 5th listed offense in the table is a person who knew or reasonably should have known that a collision, etc., might result in the death of another person and the death actually occurred. That is guilt. That the violator would be guilty of a felony and is subject to imprisonment up to 10 years and a fine of up to $10,000. The comparables for these offenses are identified on page 8. The guideline subcommittee recommends classifying the 2 5-year violations as person offenses with seriousness categories of 5, and the 10-year violation, the one involving person who reasonably should have known that it might result in death and death actually occurred, the 10-year, that is subcommittee is recommending classifying that as a person offense with a seriousness category of 4.
Thank you.
The subcommittee moves for the commission's acceptance.
Is there a second? I'm just looking at Mr. Finchie. Thank you, Ms. Saunders or Mr. Finchie. Thank you. It's been moved and properly seconded to adopt, moved and properly seconded to adopt the recommendation of the committee. All those in favor? All those opposed? Any opposed? Thank you. Motion
Abstention.
carries.
All right, great. Moving on to page 9, and this is where we start with the review of changes to existing offenses that have recommended action. And we're going to begin here with chapter 136, which is House Bill 413. House Bill 413 specifies that a violation of Section 5-612A of the criminal law article relating to manufacturing, distributing, dispensing, or possessing certain large amounts of certain controlled substances is a felony. So this bill alters the penalties for being a volume dealer and a drug kingpin with regard to cannabis. A violation of the prohibition against being a volume dealer of cannabis is a misdemeanor and is subject to imprisonment not exceeding 10 years and/or a fine not exceeding $50,000. A violation of the prohibition against being a drug kingpin with regard to cannabis is a felony, subject to imprisonment not exceeding 20 years or a fine not exceeding $100,000. The comparables are provided on page 10 of the memorandum, and based on these, the subcommittee recommends classifying, the cannabis volume dealer 10-year misdemeanor as a drug offense with a seriousness category of 4, and the cannabis drug kingpin 20-year felony as a drug offense with a seriousness category of 3B, as in boy. Present that as the subcommittee's recommendations.
The subcommittee moves for adoption by the commission.
Thank you. Is there a second? Thank you. It's been moved and properly seconded to adopt the recommendation of the committee. All those, I'm sorry, is there any discussion?
Yeah, I
All
see
those-
Mr. Fincy's hand up.
Was it?
Mr. Fincy's hand is up, Judge Middleton.
Not
He
on
said there's nothing.
purpose.
He said there's nothing.
No,
He
it's
doesn't
not
mean
up on
to.
purpose. I'm trying to figure out how to get it down.
Okay, I got you.
Right. Okay, thank you. All those in favor? Any opposed? Thank you. Motion carries.
Okay, great. Moving on to page 11. We are on page 11. We will continue with changes to existing offenses. Now we're talking about chapters 465 and 136, which relate to Senate Bill 443 and House Bill 413. This is a little bit unique the way we organize these here. These were not cross files. And we already reviewed a portion of House Bill 413 in the previous discussion, but we combine these together because the offenses are all related with weapon offenses here. So relevant to this discussion, first starting with House Bill 413, this legislation reclassifies a violation of Section 5-138 of the Public Safety Article, specifically the offense of possessing, selling, transferring, or otherwise disposing of a stolen regulated firearm. It's reclassified from a misdemeanor to a felony and provides that each violation of the section is a separate crime. This offense is already classified as a seriousness category 6, and the guidelines subcommittee recommends keeping that classification as the maximum penalty did not change. Next, House Bill 413 reclassifies violations of sections 5-406 of the Public Safety Article involving distribution and sale of a handgun not included on the handgun roster from a misdemeanor to a felony, and provides that upon conviction, a violator is subject to imprisonment not exceeding 5 years. For reference, the Handgun Roster Board within the Maryland Department of State Police compiles and maintains a list or roster of handguns approved for manufacture or sale within the state. So this is related to a violation of that. So for the related handgun roster violations listed as the second and third offense on the table, and based on the comparables provided on page 12, the subcommittee recommends classifying both of them as person offenses with a seriousness category of 6. Next, House Bill 413 reclassifies under Public Safety Article 5-703 the prohibition against purchasing, receiving, selling, offering to sell, or transferring a ghost gun from a misdemeanor to a felony. Similar as before, this offense is already classified as the seriousness category 5. I'm now looking at the fourth row if you're following along on the table. This is already seriousness category 5. Only the misdemeanor felony classification changed while the maximum penalty did not. So there's no recommended seriousness category change here. And then last, under Public Safety Article 5-140, Senate Bill 443 and House Bill 413 reclassify the prohibition against transporting a regulated firearm into the state for the purpose of unlawfully selling or trafficking the firearm. And that was reclassified from a misdemeanor to a felony. Once again, this offense is already classified in the guidelines offense table, and it's classified as a seriousness category 4. And the subcommittee is not recommending any change to the seriousness category because, again, the maximum penalty did not change. So I will present this block of recommendations as the subcommittee's recommendations related to these weapon offenses from Senate Bill 443 and House Bill 413.
The subcommittee moves for the commission's adoption.
Thank you. Is there a second? Thank you. Second by Senator West and Mr. Finchy. All those in favor? Any opposed? Thank you. Motion carries.
Okay, great. So, we are now on to, excuse me here, I lost my place for a second. We're now moving on to page 13. So I apologize for that. We continue with changes to existing offenses. And this is the last individual offense we will have to review. So this is continuing with Chapter 180 and House Bill 260. House Bill 260 reduces the penalty for a violation of Section 5-620 of the criminal article, which prohibits the distribution of controlled paraphernalia under certain circumstances from imprisonment not exceeding 4 years and or a fine not exceeding $25,000 to now being just a fine. And so it's a fine not exceeding $500 for a first violation and imprisonment not exceeding 1 year and or a fine not exceeding $1,000 for a subsequent offense. So that's a reduction for a first violation to from the 4-year statutory max to now no period of incarceration. The bill also reduces the penalty for a subsequent violation of Section 5-619C of the criminal article, which prohibits the use or possession with intent to use drug paraphernalia for certain persons from imprisonment not exceeding 2 years and or a fine not exceeding $2,000 to now being imprisonment not exceeding 1 year and or a fine not exceeding $1,000. Lastly, the bill reduces the penalty for subsequent violation of 5-619D, which prohibits a person from delivering, selling, or manufacturing or possessing with the intent to deliver or sell drug paraphernalia when the person knew or should have known that the paraphernalia would be used for certain purposes. And so this penalty was reduced from imprisonment not exceeding 2 years to imprisonment not exceeding 1 year. So the first offense that's listed here in this table applies to a first violation of drug paraphernalia, and it no longer includes the possibility of incarceration. So the recommendation is that it will be removed from the guidelines offense table because the guidelines do not apply to offenses that do not carry the possibility of incarceration. The remaining 3 offenses were included primarily for informational purposes. The offenses were revised, so they now each carry a 1-year maximum penalty. So as I already previously mentioned, any offense with a maximum penalty of 1 year or less will automatically receive a seriousness category 7 unless the commission would want to choose to adopt a different seriousness category. So the subcommittee recommends no action as these offenses will automatically be assigned a seriousness category 7 unless the commission wants to discuss them further in any way. So I recommend I present that as the recommendation of the subcommittee.
The subcommittee so moves for the commission's adoption.
Oh, second, thank you by Mr. Finchie and Judge DeLeonardo. Thank you. Any discussion? No. All those in favor? Any opposed? Thank you. Motion carries.
Okay, great. So for the remainder of this memorandum, pages 14 through 29, there is no recommended action from the subcommittee. The subcommittee recommends no action on the remaining offenses for a few reasons. The bills either one, offer no change to the criminal penalty structure for the specific offenses, or two, they are new offenses with a maximum penalty of 1 year or less. And as I mentioned now several times, we have the longstanding policy that anything with a penalty of 1 year or less will automatically be classified as in the lowest or least stringent seriousness category, which is 7. So for these primary reasons, the subcommittee recommends no action for the remaining legislations that are reviewed starting on page 14 and going forward. The staff is happy to review any specific legislation and corresponding offenses that have no designated action, but we defer now to the commission to decide if any legislation or offense-specific review is necessary for those.
So before we make a motion, I would just like to give everyone the opportunity. I know you've read it, but just to scroll through to see if there's anything that you feel we need to discuss before we vote on it. There are a number of pages, so.
Yes.
Okay, does anyone have any questions or concerns? If not, the subcommittee moves for the commission's adoption.
Second, thank you by Mr. Finchie. Thank you. It's been moved and properly seconded that the committee take no action on the remaining items. All those in favor? Any opposed? Motion carries.
All right, thank you so much. Appreciate that. We'll now move on to the next item on the guidelines subcommittee report. This is the proposed guidelines revisions in response to Senate Bill 152 and House Bill 89. And I'm going to hand the reins over to our graduate research assistant, Julia Caspero, to introduce this topic to us.
Thanks. Good evening. The corresponding meeting memo for this item is titled Proposed Guidelines Revisions in Response to Senate Bill 152, House Bill 89. As you may recall, the Commission met on January 7th of 2025 to discuss the potential impact Senate Bill 152, cross-filed with House Bill 89, would have on the Sentencing Commission's work. At the time, the Commission decided to submit written testimony for Senate Bill 152's hearing, which took place on January 9th. Since then, Senate Bill 152 was passed by the Maryland General Assembly. The bill provides that each animal harmed in a violation of Section 10, Subtitle 6 of the Criminal Law Article is a separate offense and shall be deemed an individual victim for purposes of the Sentencing Guidelines Stacking Rule, or what is referred to in the Maryland Sentencing Guidelines Manual, or MSGM, as the Multiple Victims Stacking Rule. Currently, Chapter 10.1 of the MSGM provides instructions for the Multiple Victims Stacking Rule, stating that when there is a criminal event with multiple victims and not more than one seriousness Category 1 or 2 offense, the person completing the sentencing guidelines worksheet shall add the highest of the upper limits of the guidelines ranges for each victim to find the correct overall range for the criminal event. Animals may not be considered victims for the purposes of applying the multiple victim stacking rule. The added instruction to exclude animals was adopted in February of 2024. It was not considered a rule change, but rather a clarification of an existing rule. The number of sentencing events potentially impacted by Senate Bill 152 is small. Only 9 of the 37 guidelines eligible sentencing events for fiscal year 24 involving crimes against animals included more than one of these offenses. Violations of Section 10, Subtitle 6 of the Criminal Law Article are also more likely to be prosecuted in the district court where the guidelines are not applied. Appendix A, found on page 4 of the memo, includes a complete list of crimes against animals found in Section 10, Subtitle 6, that are included in the Maryland Sentencing Guidelines offense table. Page 3 of the memo includes the proposed revisions to the MSGM and Code of Maryland Regulations, or COMAR, in response to Senate Bill 152. They revised the sentence clarifying that animals may not be considered victims to state each animal harmed in violation of Section 10, Subtitle 6 of the Criminal Law article shall be considered a victim for the purposes of applying the multiple victims stacking rule. That concludes my summary. Please let us know if you have any questions, but otherwise I'll turn it over to the commission.
Thank you, Julia.
Thank you. Is there any discussion?
So I think this is what we discussed for a long time last term, right before the legislation. And I think the legislation is pretty consistent with our discussions.
Yes.
I have a proposed amendment to the entry to be made into MSGM paragraph 10.1. I would propose that since this is a change, not in policy, but a statutorily mandated change, that we just simply add the phrase pursuant to criminal law article section 10-627, comma, each animal harmed in violation of section 10 subtitle 6 of the criminal law article shall be considered a victim.
Could you restate that, Mr. Fenty?
Sure. Simply proposing that we amend the paragraph 10.1 edit that has been proposed and add the phrase pursuant to criminal law article section 10-627 and then comma, and then continue with the wording proposed by the staff.
So we would still leave in section 10, subsection 6 of the criminal law article?
Yes, I think that relates to
Okay.
the overall statutory scheme for causing harm to animals.
It also clarifies that it only applies to animal offenses in that specific subsection and not all animals in general, or any animal involved offense.
Well, I think that's consistent with what the subcommittee, what our discussions were. Judge DiLeonardo, I was going to propose that the commission accept the recommendations of the subcommittee with this one addition.
I second that.
Okay.
Thank you. It's been moved and seconded that the committee approve the recommendation with the amendment from Mr. Finchie to include the language pursuant to criminal law article section 10-627, blah, blah, blah. All those in favor? Oh, is there any further discussion? Okay, all those in favor? Any opposed? The motion carries.
Okay, I think that concludes the guidelines subcommittee report. Thank you, everyone. Judge Middleton, with your right, I'll just jump right into the next section, the executive director report, if you'd like me to proceed.
Yes, you'll proceed.
All right. Thank you. I have 4 items to report today. First, I want to speak about 2 July 1, 2025 sentencing guidelines updates. The first relates to at one of our earlier meetings in September of 2024, we voted to revise the list of common departure reasons. As you all know, departure reasons from the guidelines. And we did that to more closely align with the reasons reflected in current guidelines data, also to reflect the input that we received from the survey of circuit court judges that we completed at the judicial conference, and then finally to provide greater insight into the circumstances of the case. So the commission also voted to revise the corresponding instructions to more clearly explain why data on guidelines departures are collected. The revised list of common departure, guidelines, reasons, and corresponding instructions were adopted in COMAR and the Maryland Sentencing Guidelines Manual effective July 1, 2025. We have distributed new, we did new color, new yellow laminated bench cards. Those are reference cards that circuit court judges keep on the bench. And we found out that they all really want the hard laminated cards. So that was a good thing that we did that. And so those have been distributed to all the circuit courts. Additionally, on July 1, there were updates with revisions to the guidelines offense table. They were mostly minor, but the offense table was updated to include some previous commission decisions. We had one previously unclassified offense, an election law offense, and then one reclassified offense and other minor non-substantive edits. So those changes went into effect on July 1. The second item to report is related because MAGs, we have two versions of MAGs that have been released since we last met as a group. So just at the same time, 1 week ago, or less than a week ago, well, it was a week, yeah, today's the 8th. 1 week ago on July 1st, the commission released MAGs 13.0. That's the most recent version. So 13.0 includes the revised list of common departure reasons and corresponding instructions. Additionally, MAGs 13.0 includes updates to the criminal offense table to include the guidelines offense table updates that I previously mentioned. And then finally, the last version of MAGs, and this is last but certainly not least, it included some extensive library upgrades that will help to maintain and secure and ensure the security and functionality of the application. So those are kind of like behind the scenes things that a user MAGs wouldn't use, but that our technical team worked really hard to deploy. So to bring stability and enhanced functionality for the application. On April 3rd, just over 3 months ago, the commission released MAGs 12.1. I'm just mentioning that now since we haven't met since that time, and because it really had a couple significant updates that we haven't spoke about as a group. The first update added an alert message that will identify a potential multiple criminal event, single sentencing event scenario. When multiple criminal events, which are often indicated by multiple unique case numbers or docket numbers, are sentenced by the same judge on the same day, that constitutes one sentencing event, and the guidelines worksheet for all case numbers should be initiated under one MAGs record or one worksheet ID. And to ensure proper calculation of the overall guidelines range in this scenario, MAGs 12.1 added a new feature that prompts users to correctly initiate a multiple criminal event, single sentencing event scenario. So if a user attempts to initiate a worksheet with the same defendant name, date of birth, and jurisdiction as a previously initiated but unsubmitted worksheet, MAGs will see that and say, hey, this looks like you might be starting a duplicate here. So it'll display an alert message prompting the user to combine the worksheets together for all case numbers within the same sentencing event under one worksheet ID. So this was a really important update because that was one of the most common errors that was happening with respect to initiating the guidelines, which was to initiate them as two separate sentencing events, and then they would need to be combined together. And so we think that this update seems to be accomplishing the goal of eliminating that error, as the staff has just observed that we are not receiving nearly as many emails or correspondence requesting that multiple criminal events, single sentencing event scenarios be combined after sentencing. So that seems to have been a really important and useful update to the application. The second MAGs 12.1 update makes it easier for worksheet submitters to identify required missing fields prior to submitting the worksheet. In MAGs, fields that are required are marked with a red asterisk, and they need to be completed prior to submission. After the MAGs 12.1 update, if a user attempts to submit a worksheet without, excuse me about that, if a user attempts to submit a worksheet without completing all required fields, an error message is displayed, and it identifies which specific mag screen is missing a required field. And so the user will not have to scramble around to try and find that. It just makes it easier for the person who's submitting the worksheet. So again, we also think this is a feature that has been well received, and it saves times for court users specifically when going in to submit completed sentencing guidelines worksheets. I do want to give a shout out to Catherine Pembroke on our staff. Catherine is our MAGS help desk manager, and she wears a lot of different hats, but she really is the engine that drives MAGS, because she's the one that leads all of our efforts to do our quality assurance test and working with our programmers teams, and she really puts in a incredible effort and amount of time to ensure that MAGS is working properly. So I did want to give her a shout out here in this meeting, because she really does an amazing job, and she deserves a lot of credit for the amount of work that she puts into making sure MAGS runs smoothly. So Catherine, we thank you for all the work you put in.
Thank you. I appreciate that.
Okay, moving on. I want to just talk a little bit about recent sentencing guidelines trainings and judiciary feedback sessions. In preparation for the April 3rd release of MAGS 12.1 and all those features I just talked about, Catherine, who is also our training coordinator, as again, I said, she wears multiple hats. She provided multiple MAGS-related training sessions throughout April to highlight these updates to our justice partners, and a recording of these webinars is available on our website. So we try to always keep those up to date and fresh, so individuals can learn about the new features that we're rolling out into MAGS. In addition to those trainings, Catherine provided another training on February 25th. In addition to that one, I participated in training on February 25th in a judicial seminar regarding structural inequality and anti-racism. And that was as one of a portion of a larger judicial cemetery on anti-racism. I provided a summary of the Commission's July 2023 report, which assessed racial differences in sentences among those who were sentenced under the criminal sentencing guidelines. So that was a really good opportunity to present the work of the Commission at that judicial conference. And then further on March 24th, I presented about the recent work and activities of the Commission to the Conference of Circuit Judges. So that was a good opportunity to share all of that information. And finally, just to keep you up to date, my goal is to meet with each individual jurisdiction. We have 24 jurisdictions in Maryland, and to meet with each of them, the circuit courts, once every 2 years. And so been getting out to various jurisdictions to do so. And since the beginning of the year, I've had meetings in Baltimore City, Baltimore County, Charles County, Frederick County, Garrett County, and Hartford County. And then additional meetings are scheduled for later in July with the circuit courts in Montgomery County, Prince George's County, and Washington County. So these meetings are really a great opportunity to share updates, to talk about things about the guidelines, what work the Commission has recently completed, but also to solicit feedback from the judiciary and from the judges, the people that are, applying the guidelines on a regular basis. And so it's great to hear that feedback. And as you know, sometimes that type of feedback leads to policy issues that the Commission then studies. So I'll be continuing with those meetings throughout the rest of the year. Finally, I wanted to provide a brief wrap up regarding the 2025 legislative session as it pertains to the work of the Sentencing Commission. So the staff prepared fiscal and operational impact statements for 92 bills during the 2025 legislative session. The staff reviewed all guidelines relevant legislation and prepared the corresponding proposed revisions for new and amended offenses that the Commission reviewed earlier in this meeting. And then finally, I just want to wrap up with a brief update regarding the two specific bills from the 2025 session that this commission met with separately. As you may recall, in January and February, we had specific meetings. So in January, we met to talk about Senate Bill 152, which cross-filed with House Bill 89. That was the legislation that did pass, and the commission just acted on that, as you know, during our subcommittee report. So that was, we discussed that in January. Then in February, we had a specific meeting on February 24th to discuss House Bill 1423. As you may recall, House Bill 1423 would have established the commission to review and assess racial disparities in the state criminal justice system. And the commission voted to support House Bill 423, but with amendments. You may recall that it would have put a strain on our resources as it was asking us to staff that commission. So we supported the overall goal of that legislation, but we, indicated that it would be, not really tenable for us to staff that new commission and be the research arm for that new commission. Ultimately, that legislation did not advance out of committee in the House. So that concludes my report. I'm happy to address any questions.
I don't have any questions, but I do want to say, while we're on the subject, I do want to sincerely thank the staff and Dr. Soule for all of the tedious work that they put into conducting the research and helping this committee to prepare to do its work. So I just want to thank you all for the preparation on 92 bills. That is no light task. So thank you so much for all of your hard work. It does not go unnoticed. So thank you very much.
It's very kind. We appreciate it. I feel very fortunate to have an amazing staff, and we work really well as a team. So I appreciate that support, and thank you so much.
You're welcome. Are there any questions, comments? Okay. We can move on in the agenda to discuss meetings, upcoming meeting dates.
Yes, correct. We have two remaining meetings scheduled for 2025. The Tuesday, September 9th, which will be a virtual meeting completed via Zoom. And then we'll wrap up the year on Tuesday, December 2nd with a in-person meeting at the Maryland Judicial Center. That is our annual dual meeting where we will do a public comments hearing first and then proceed to a business meeting immediately after that.
All right, thank you. Any questions? All right, moving on. Any old business? Any old business? Any new business? Yes, any? I saw you. Delegate Bartlett.
I wasn't sure where this would go. That's why I didn't say anything. Well, Dr. Soule and everyone, I listened very intently while we were during our meeting, but I also was doing some research. And I was texting and doing different things. It seems that the portion that I was thinking of was amended out of the bill. And so therefore, I wanted to give you all, the guidelines subcommittee does such an excellent job that if I could lighten your load, I'd like to do that. So it was amended out of the bill. It is only a property crime. Thank you.
We are happy that you were able to complete that research at the time. So that's very helpful. Thank you.
Thank you.
Thank you. Less work for the subcommittee. Thank you.
Any other announcements? Any other announcements? All right. Well, thank you all for being so efficient. Welcome, Commissioner Ross.
Mhm.
Thank you. I hope
Thank
you
you
guys,
very much.
yep, that was your quick lesson.
See,
I have a question, and I know it, forgive me because if this is ignorant, but
No problem.
how quickly does the offense table get updated once these
It's a good question.
changes are approved?
That is an excellent question. It is not ignorant in any way, because I don't think that's most people would know that at all. So, 3 to 4 months is the answer. The guidelines are promulgated as regulations, so that means anything that we adopt as a committee, we need to go through the proper adoption process, which involves publishing the proposed amendments in the Maryland Register, allowing 45 days for public comment, and then another extra 15 days. That part I never really understood. And then ultimately, we have to publish a final notice saying we're going to adopt our recommendations as proposed. So that whole process takes about 3.5 months, 4 months. So I would expect that we would adopt the changes that we voted on today, effective November 1, maybe to December 1 is an expected timeline.
Gotcha. So so essentially, as a person that's applying these on a day-to-day or, a regular basis, I'm still going to be operating under what's currently published, and then I'll be updated or notified once those take effect.
Correct.
Okay.
Correct. Yeah, and we'll send you out, a guidelines e-news to all of our justice partners. Hopefully you're on that distribution list
I believe I
to get
am.
an update regarding, anytime there's any changes or updates to the sentencing guidelines. And if you're not on
Awesome.
that
Thank
list,
you.
we should rectify that immediately.
I do believe I am. I think I spoke to Catherine about that previously, and I'm pretty sure I am. If not, I will follow up and let you guys know.
Yes, you are. I've confirmed.
Thank you, Catherine.
Thank you. Thank you for that question. Are there any other questions? All right, well, this meeting is adjourned. Thank you all. Enjoy your summer.
Yes.